in any criminal investigation. So I would think that if there are indictments, the most likely outcome is that it does not end up going to trial, but it certainly could.
Okay. Sam Markison, U of L Law School professor. He will be one of our experts we'll be talking to after the announcement. Again, the grand jury presentation coming up in a minute. First, I want to check in with Sanait Gavrigegadis, who's been so close to the family during this for the last several months. Sanait?
Well, yeah, Doug, just a little while ago, I spoke with the original attorneys who were representing Breonna Taylor's family before they reached a civil settlement in this case. They tell me, Launita Baker and Sam Aguilar, they tell me they will hold a news conference after we learn the findings from the grand jury and after Daniel Cameron makes an announcement. They say it's going to be in Louisville, and they will let us know as soon as they come up with a plan. And of course, we're right across Jefferson Square Park, the epicenter of the protest, because Louisville Metro Hall has been one of the locations, along with City Hall, where the family has held their own demonstrations and protests. And of course, one of the largest events happened here, Breonna Taylor's 27th birthday, where the city came out and where we started seeing more people stand in solidarity with them. And again, Doug, the family says they will hold a news conference. They will share their thoughts. We don't know if all the family members will be there, but we know their representatives will be there to share comments and to share how they're feeling after the findings come out. And of course, they've been waiting for justice. This moment is something that everyone has been waiting. It has caused the city to shut down. It has brought the family together with their supporters. National social justice groups have came down here. So we will be there, Doug, when the family makes that happen, and we'll be sure to bring you more.
Well, Sanait, before you leave, set the stage for me in the square there. How are people watching this announcement? Is everybody on their phones? I know in the past they've brought big screen televisions out there. What are you seeing around you?
Yeah, well, let me show you a live look right now. This is Jefferson Square Park, and things are pretty calm. Obviously, downtown is shut down. The streets are closed. No cars can go through here, no traffic, but they're all surrounded. We heard messages about people saying they want to see justice and how they're not going to stop here if there are no criminal charges and if they don't see what they've been demanding for months. We saw Until Freedom recently just say they will continue to spread the message around the world, not just across the country like we've been seeing happen these last couple of months, but they will spread the message. They are not announcing their plans and what that may look like, but they made it very clear that they will be back and they will try to find ways to bring justice for the family who's been trying to bring this story out of the shadows for almost 7 months now. October 13th will mark the 7th month mark since Breonna Taylor was shot and killed in her apartment, and they made it very clear they're going to continue organizing and demonstrating. But right now, things are very calm. People are just on their phones, they're taking pictures, they're sharing messages, and they're just hoping for the best.
Okay, Sanait, thank you very much joining our team in Jefferson Square, where a large and growing group has just been standing around, very peaceful in Jefferson Square right now. Let's show you the live picture there from the Jefferson County Grand Jury getting ready to present. Okay, they are not up just yet. Scheduled to start at 1:15, so we're just a couple of minutes away from that. You're going to see it here live. Let's go through the timeline of the case as we lead up to the grand jury decision here. This case actually goes back to March 12th, when Judge Mary Shaw signed off on 5 warrants as part of a large narcotics investigation underway in the city.
I think for now we're good.
Including one for Breonna Taylor's apartment. Okay, can we go live now to the grand jury? Is that what I'm being told?
Members of the grand jury sitting in Jefferson County in the month of September. I also have with me today a representative of the Office of the Attorney General, our court administrator. For the information of the public and anyone observing who's not familiar with the process, once the report is received from the grand jury, if there are any indictments, I will ask the foreperson to randomly select a number. The case will then be assigned to the courtroom or division that corresponds with the number that has been selected by the foreperson, and the courtroom will, that case or those cases will then proceed in those courtrooms assigned for further proceedings. The indictment itself, that is to say the charging document in this case, will be transmitted to the Jefferson County Clerk's office. It will be recorded and made publicly available through that office. And so I will begin the report of the Jefferson County Grand Jury. In the matter of Commonwealth of Kentucky versus Brett Hankison, the Jefferson County Grand Jury charges as follows. Count 1, wanton endangerment in the first degree. On or about March 13th, 2020, in Jefferson County, Kentucky, the above-named defendant, Brett Hankison, committed the offense of wanton endangerment in the first degree when, under circumstances manifesting extreme indifference to human life, he wantonly shot a gun, into the apartment occupied by initials CE. Count 2, wanton endangerment in the first degree. On or about March 13th, 2020, in Jefferson County, Kentucky, the above-named defendant, Brett Hankison, committed the offense of wanton endangerment in the first degree when, under circumstances manifesting extreme indifference to human life, he wantonly shot a gun into the apartment occupied by initials CN. Count 3, wanton endangerment in the first degree. On or about March 13th, 2020, in Jefferson County, Kentucky, the above-named defendant, Brett Hankison, committed the offense of wanton endangerment in the first degree when, under circumstances manifesting extreme indifference to human life, he wantonly shot a gun into an apartment occupied by initials ZF against the peace and dignity of the Commonwealth of Kentucky. Mr. Foreperson, is that the decision of the grand jury? Thank you. Sir, if you would please randomly select a number.
Megan, this goes back to the chief's firing letter.
Division 13. Thank you, sir. The case will then be assigned to Jefferson Circuit Court, Division 13. Madam Assistant Attorney General, do you have a motion with respect to bond?
Yes, Your Honor. The Assistant Attorney General asks for $15,000 full cash bond for the defendant, Brett Hankison.
I will grant the motion and assign bond in the amount of $15,000 full cash and issue a warrant. That concludes the business of the grand jury sitting for Jefferson County in September 2020. Thank you, ladies and gentlemen. You may be excused. I'm going off the record.
All right. Well, there you have it, and let's take a look live at Jefferson Square as we can for a moment, and we'll go over for you what we have here. Maybe we'll also get Sam Markison from U of L back on the phone here. But 3 counts of wanton endangerment for Brett Hankison, the police officer who was fired by the interim Metro Police Chief Robert Schroeder for firing blindly his weapon. 3 counts of wanton endangerment, again, is exactly what we were told here by U of L law professor Sam Markison could happen. Going back to the letter from the interim police chief, I've got it right in front of me here, and this has been pointed out to us by our legal experts along the way here, that the police chief actually wrote his letter about the firing of Brett Hankison based on the legal standard that exists. I have determined you violated standard operating procedures when your actions displayed an extreme indifference to the value of human life, when you wantonly and blindly fired 10 rounds into the apartment of Breonna Taylor on March 13th, 2020. The chief, on June 23rd, went on to write, "These rounds created a substantial danger of death and serious injury to Breonna Taylor and the 3 occupants of the apartment next to Ms. Taylor's. Blindly firing 10 rounds into Breonna Taylor's apartment without supporting facts that your deadly force was directed at a person against whom posed an immediate threat or danger or serious injury to yourself or others. In fact, the 10 rounds you fired were into a patio door and window, which were covered with material that completely prevented you from verifying any person as an immediate threat, or more importantly, any innocent persons. You further failed to be cognizant of the direction in which your firearm was discharged. Some of the rounds you fired actually traveled into the apartment next to Ms. Taylor's, endangering the 3 lives in that apartment." Now, Brett Hankison appealed with his letter, and we want to show that to you here. But again, the only indictments coming down here moments ago against Officer Brett Hankison, the other officers in this case, Miles Cosgrove, Jonathan Mattingly, and Joshua James, did not have any indictments against them here. This coming out from the Jefferson County Grand Jury's presentation. Now here, let's look at this right here. This was the appeal letter. Among the few things presently established in the ballistics regarding the bullets fired have been compiled, although they have not been released. Notably, the charges do not allege that any round discharged by Hankison struck Ms. Taylor. So we want to get reaction here as we are waiting for just a few minutes before Kentucky Attorney General Daniel Cameron presents his findings next. And let's go to Shay McAllister. She is live at Jefferson Square at the moment. Shay, give me your thoughts and what's been the reaction there around you.
But yet we have so far to go.
Hey, Doug, right now I think it's still really sinking in. People asking each other, what exactly does this mean? What do those charges mean? Who is charged? As people realize, a lot of disappointment, a lot of people hurt. We have seen people crying and hugging each other. The big group up near that big white tent are explaining this, explaining what this means, what could come next. I think for a lot of people here, they're still waiting to find out what happens and if Attorney General Daniel Cameron might say something more. There was initial reaction, but it wasn't dramatic. A few people clearly understanding exactly what that meant. Only Brett Hankison facing charges from the grand jury. Others, though, seem to be still waiting for the next thing. And if you take a look around, a lot of media here. We're seeing a lot of national media here, too, and a lot of community members. Sadiqa Reynolds told us earlier today that she was asking people to keep it peaceful here no matter what, but she was hoping for justice. She was hoping that there would be some accountability here, and we'll have to reach out and see what she thinks about that now. As far as what you're seeing here, calm, quiet, a lot of listening, and a lot of questions, Doug.
Well, Shay, first-degree wanton endangerment. You've been investigating this case along with several members here of our staff. You know, at this moment, it means that none of the hierarchy, the higher level of charges came down against any of the other officers.
Right, and I think a lot of people were asking for some of those higher degrees of charges. Of course, the motto from many down here in Jefferson Square Park has been arrest those officers, charge them with murder, fire them. That has been what they have been asking for the last several months, and today it sounds like that may not be what happens.
Tonight, Gabrigagadis, she has been following the family on this and is also at Jefferson Square right now, just across the way from there. Tonight.
Well, yeah, Doug, I reached out to the family's original attorneys, again, Sam Aguiar and Lonita Baker. I haven't heard back yet, but before that indictment was announced, they said they will hold a news conference in Louisville, but they're waiting until Daniel Cameron makes his announcement. Of course, we're expecting that here soon. And this is what they've been demanding: murder charges for all the officers. So we will
Megan,
be here waiting to hear their response. And the mother has been demanding murder charges for all the officers. And Doug, I'm going to send it back to you now.
Okay, thank you very much, Sinite. As we listen to the indictments, first-degree wanton endangerment coming down for Brett Hankison, it is clear that they were naming the other apartments around Breonna Taylor's apartment there, which is on the first floor. And Hankison, of course, was fired by the police chief because he was firing blindly into the other apartments there and also into Breonna Taylor's apartment. But it appears these wanton endangerment charges, because as you heard the grand jury foreman give initials of the other residents living around Breonna Taylor's apartment there. So it seems to me that that was, and we do have some previous interview here since taking on the case in May. Attorney General Daniel Cameron has promised a fair and independent investigation, often asking for patience from those who have criticized the time it's taken to get to today's decision. And here's what he told our Chris Williams back on July 17th.
A team of dedicated prosecutors and investigators are looking at this. We put blinders on as it relates to any of the outside criticism that we might get. At the end of the day, you recognize that in a free society, there's going to be criticism. in public life. I understand that. I accept that. We will not be deterred from getting to the truth of this matter. Again, recognize the passions that are involved in this case, and that is why it's so incredibly important that we get to the truth at the end of the day.
Before that interview on July 14th, protesters marched to Cameron's East End home and they held a demonstration on his lawn. 87 were arrested on several charges, including a felony of intimidating a participant in a legal process. The Jefferson County attorney later dropped that felony charge. Now we have reaction coming in to people who were just listening to the Jefferson County grand jury. And we will be going to more of that reaction here in just a moment. Some of the people in Jefferson Square, I'm being told, are actually crying in Jefferson Square, in the street there. It is quite emotional. Of course, they were looking for a higher level of charges. And next, coming up down the line here, will be Kentucky Attorney General Daniel Cameron, who will be presenting his case of the grand jury. We have already been told by WHAS 11's Chris Williams that the Attorney General did not investigate the obtainment of the key search warrants in the Breonna Taylor case, which was key there. Let's go to Shay McAllister. She is in Jefferson Square now with Pastor Bruce Williams of the Bates Memorial Church here in Louisville. Shay?
Hey, Doug. Yeah, Pastor Bruce Williams here. Okay, you know what just happened. What do you think?
Yeah. Well, it's a tragedy. It's a travesty of justice, and just exposes just how rancid and this racism is in this city. They keep wanting to call it a compassionate city. There's nothing compassionate about what just took place. We are numb right now, but we're determined. They're going to continue to help the city know that we're not finished. And we have some things beyond this as well, and that is that we're going to lay this at the feet of people we think are responsible. Many of the elected officials, we want them to understand that we'll be identifying and preparing people to take their places. Many of them, because of their decisions and actions and lack of actions, have been complicit with what has taken place. And we have a determination that will not be squelched by this decision, but this is an awful decision, and it is a backhanded slap in the face of not only justice, but all the people who've been here trying their best to encourage our city to do the right thing. And it's just more evidence that no matter, it appears that they are just entrenched in not listening to the masses of people and not being committed to the justice that people deserve.
What do you think happens next, specifically here in Louisville, even as soon as today and tonight?
Well, that remains to be seen. I know that the people those of us who've been protesting and been fighting for justice in the city for a while are going to continue. We're going to the next phase of what we're attempting to do. And this city is going to understand that it can't continue to treat its citizens the way it does. And especially black people the way they do, and continue to have a justice system that just does not favor justice when it comes to black people. So you'll be hearing more in the future about what we'll be doing, but it's not over. We meant it when we said no justice, no peace, and so we'll be finding all kinds of ways to make sure that this city changes. Our city needs a change. It really needs a change. Louisville needs to change. This is old. I think some people in power think that this is just going to be one of those things that if we just endure, it will pass away. That is not the case. This is not going to just pass over. It's not going to blow over. We're not going back to business as usual. We are not going back at all. There's no way to go back. And so they might as well get ready for pressure. They might as well get ready for holding people accountable, from the mayor to the city council to any elected official that's been complicit. Please understand that we are tired of being treated the same way and expected us to just roll over and play dead. That's not going to happen. It's a new day, and you'll hear from us.
Can you describe the mood here? I mean, it was quiet for a minute, I think, as people were letting it sink in, but now we're starting to hear some real hurt.
Well, one of the things you know when it comes to grief cycles is the first thing is you're numb. You can't believe it. And, you know, the masses of people we knew just from the history of this city and the history of this country that we didn't really expect. We hoped against hope, but we didn't really expect it to be any different. But you kind of hope that maybe somebody will wake up. And what has happened is they're numb because of the audacity of this decision, the audacity of the racism, the audacity of the evil. It's just, even though you know you've experienced it before, the audaciousness of it just makes you numb. And then after you get past or process that numbness, you're angry about the injustice. And if you're not angry about this injustice, then there's something seriously wrong. And we're going to take this anger, this power, this passion, and we're going to focus it on change that absolutely needs to happen in Louisville, Kentucky. We are committed to change.
All right, Pastor Bruce Williams, thank you so much. Thanks for taking a second. Doug, we're going to send it back to you as people start to hit the streets. It looks like marching might be getting ready to start here.
Okay, Shay, thank you very much. I appreciate it. We also have a live camera on Jefferson Square from a downtown building. We'll be keeping an eye on that. Again, coming up next here within just a few minutes, Kentucky Attorney General Daniel Cameron announcing his results of the grand jury proceedings in an investigation into the death of Breonna Taylor. A few moments ago, we were told that it was about 2 minutes away. Here's our live camera as we are looking at Jefferson Square from across the street, as Shay said that they were getting ready to march. Louisville Mayor Greg Fisher during the noon hour said that he was called by the Kentucky Attorney General, but he did not know what the decision would be. The mayor went ahead and announced a 72-hour curfew starting tonight from 9 p.m. to 6:30 a.m. Exempt from the curfew, people who have to go to work, houses of worship, or in the medical field. Also, the interim police chief, Rob Schroeder, says whatever the decisions, our officers will keep doing what they've been doing. By that he meant that they would be on duty and stay on duty today and continue to protect the city from whatever is to come. Let's check in with Sinai Gabagega. She's also giving us another view of Jefferson Square Park. Sinai?
Yeah, Doug, there's a lot of emotions right now at Jefferson Square Park. We just heard people saying this is not over. They will continue to
charge the cops that killed Breonna Taylor.
You can hear again the outrage and the frustration right now after that indictment was announced only for Brett HANKISON. And I do want to talk about professor of law, University of Louisville professor of law, Sam Markison. I had a conversation with him, did a story with him before these charges were announced. And he predicted exactly what has happened right now. He said there is not enough evidence to prove what happened right now with the lack of body camera footage. He talked about the importance of the ballistics report and how that will really help match up the statements with the affidavit of the officers when we heard, for example, Sergeant John Mattingly's police audio interview. But he said because Brett HANKISON was not only fired, but he shot blindly 10 rounds through a patio door that was covered, that he would most likely face at least wanton endangerment, which of course we saw the 3 counts of wanton endangerment. But this is not what the family wanted. They wanted all the officers to be held accountable for the death of Breonna Taylor, especially Tamika Palmer, who is Breonna's mother. She's been out here joining them at Jefferson Square Park the last couple of months. Of course, we're still waiting to hear from the family, but she's been out here showing support, and she's had an army of supporters stand behind her, standing in solidarity. And of course, you can see how much that has grown right now. Looks like some of them are going to start marching soon, but a lot of them passed by and said, I want you to know this is not over. This is not where it ends. Even though the grand jury made their decision, we are not done, and we're going to come back and continue fighting for Breonna, Doug.
Okay, tonight, thank you very much. And again, it is not over because we have one other major announcement coming up. That's from the Kentucky Attorney General, Daniel Cameron. He's going to be speaking from the Kentucky History Center in Frankfort. Again, the grand jury, which has been meeting, we had been hearing for several days in Louisville, could have considered 4 degrees of homicide charges from reckless homicide to murder. There were 12 grand juries, and they could have also considered the charge of wanton endangerment, and they did. They came back with 3 counts of first-degree wanton endangerment with a $15,000 full cash bond, and they have since issued a warrant for Brett Hankison, as they announced there at the end of the grand jury proceedings. Most of those wanton endangerment charges, most all of them coming from the bullets that went into nearby apartments. A 5-year-old was sleeping in one of those apartments, also a pregnant woman in one of the other apartments. Here's some of the facts of what we know about Officer Brett Hankison. We can pass along former Officer Brett Hankison. He has, of course, been fired by the police chief there. Detective Hankison worked for LMPD from 2003 until his firing on June 23rd. He is appealing that termination. His personnel record shows a professional standards unit investigation found that he violated department policy 3 different times between 2005 and 2009. He's also being sued in federal court for allegedly arresting a man repeatedly and planting drugs on him. Hankison did receive commendations for helping a teenager who was contemplating suicide and his work in a human trafficking case and others. Again, the firing letter sent to him by the police chief specifically mentioned the wanton endangerment statute when it was written by the police chief back on June 23rd. As the chief was stating, firing 10 rounds through a patio door and a window at Breonna Taylor's apartment, which were covered with material that completely prevented you from verifying any person as an immediate threat, or more importantly, any person's presence. Brett Hankison was also on the outside of the apartment before the other officers went in, according to a recorded interview from John Mattingly. And before they conducted the raid, which happened at about 12:40 a.m., he was arguing with another resident there at the apartment. Let's show you live pictures from downtown Louisville, where I'm being told that some trash cans have been set in fire, as there is anger, and people are upset over the fact that just wanton endangerment charges were brought back here. The other officers in this case, John Mattingly and Miles Cosgrove. Mattingly went in the apartment first that night, and Miles Cosgrove was behind him as a backup. But as you can see, some of the crowd there in downtown Louisville, so far generally peaceful. We have heard people screaming and crying, not upset with that, very upset with the decision that have just come back, but we still have the decision coming in from Kentucky Attorney General Daniel Cameron, who could explain even further or pursue the case even a little bit more. But at this point, we do know what he will not be considering, and that is he did not investigate the obtainment of the search warrants. There were key questions brought up about those search warrants. So let's go also to Shay McAllister, who can join us again. She is in Jefferson Square Park, where she told us just a while ago that they're getting ready to march, or are now. Shay?
Hey, Doug. Yeah, several dozen now marching right down here. We just passed Ali, and it sounds like this is what's happening now. They're encouraging everyone to get into the streets. They're encouraging everyone to speak out. They're saying the time to talk is done. Now it's action. And you can see it up ahead this way, heading straight down 6th Street. They haven't told us where they're planning on going, where their final destination is. But all of these people were in Jefferson Square Park just a couple of minutes ago.
Okay, we'll keep an eye on this. Let's stay live on this picture if we can, and I'll let you know who is in town. According to the interim police chief who briefed us at noon, he's getting help from the Kentucky State Police, the Kentucky National Guard, local, federal, helping LMPD. He detailed St. Matthews Police Department, Jeffersontown Police Department, the FBI, ATF, also Federal Protective Services. As we have been showing you, they are protecting federal buildings in downtown Louisville. This has been the direction that the protesters usually take every night as they head down to Broadway and where the federal buildings sit. And so, as you know, much of the city is barricaded. They really started restricting car traffic through some of those entrances. You heard the police chief earlier today say, that you could get in at some of those entrances, but I found when I was coming down here to the television building that they had already stopped letting some cars come in through some of those entrances and had even restricted even further so you could go in some of the other routes. And so they knew the decision was coming and that it was pending. Again, if you're just joining us, we are just a few moments away from Kentucky Attorney General Daniel Cameron. He will be speaking at the Kentucky History Center in Frankfort. I am being told that the family of Breonna Taylor is there, and as Senate Gabor-Gegitis has told you, they will be speaking on what comes after this news conference, because we could learn some new details as we move ahead there. The mayor once again telling us earlier today that he had not heard from the Attorney General. So let's go through some of the timeline of this case as we wait, sort of the run-up to the decision by the Kentucky Attorney General Daniel Cameron coming up in Frankfort. We can go through the case one more time for you as we review the facts. The case actually goes back to March 12th. That was a day that has not been talked a lot about in this, but that was the day when Judge Mary Shaw in Louisville signed off on 5 warrants as part of an overall large narcotics investigation. As Chris Williams reported here just a little while ago, right here, the Attorney General will not be taking on the case of the larger issue of the narcotics investigation, including the case involving Jamarcus Glover. But the investigation did wrap into one including Breonna Taylor's apartment. She was on the warrant, but she was not the focus of the warrant. The warrant was served at around 12:30 in the morning on March 13th. Breonna's boyfriend, Kenneth Walker, has admitted to firing 1 shot after police came through the door with a battering ram. Now that shot did hit Sergeant Jonathan Mattingly in the leg. He suffered a serious injury. Mattingly, Miles Cosgrove, and Brett Hankison all returned fire. Breonna was hit standing in her hallway. Mattingly said in his recorded interview that when he came through the door, Kenneth Walker was on the right, Breonna Taylor was standing on the left. And we have yet to learn who fired the fatal shots. She was struck 5 times. There's also been a report that she was struck 8 times. Officers later found her inside the apartment unresponsive. Walker was arrested and charged with attempted murder of a police officer. Then on April 27th, Breonna Taylor's family filed a lawsuit against the officers involved in the shooting. Now let's go live to the Kentucky History Center, Kentucky Attorney General Daniel Cameron with his findings.
Good afternoon. Thank you for joining us today. I know that many in Louisville and across the Commonwealth and country have been anxiously awaiting the completion of our investigation into the death of Miss Breonna Taylor. Prior to this announcement, I spoke with Ms. Palmer, Breonna Taylor's mother, to share with her the results from the grand jury. Many of you in this room know that I had the opportunity last month to meet in person with her and other members of Ms. Taylor's family, including Ms. Bianca Austin and Ms. Janiyah Palmer. I want to once again publicly express my condolences. Every day, this family wakes up to the realization that someone they loved is no longer with them. There's nothing I can offer today to take away the grief and heartache this family is experiencing as a result of losing a child, a niece, a sister, and a friend. What I can provide today are the facts, which my office has worked long and hard to uncover, analyze, and scrutinize since accepting this case in mid-May. I urge everyone listening today to not lose sight of the fact that a life has been lost, a tragedy under any circumstances. The decision before my office as the special prosecutor in this case was not to decide if the loss of Ms. Taylor's life was a tragedy. The answer to that question is unequivocally yes. There is no doubt that this is a gut-wrenching emotional case, and the pain that many people are feeling is understandable. I deeply care about the value and sanctity of human life. It deserves protection, and in this case, a human life was lost. We cannot forget that. My job as the special prosecutor in this case was to put emotions aside and investigate the facts to determine if criminal violations of state law resulted in the loss of Ms. Taylor's life. This included examining the actions of Sergeant Jonathan Mattingly, Detective Brett Hankison, and Detective Miles Cosgrove, the three officers who fired their weapons in the early morning hours of March 13th. In working with our federal partners on this case, it was determined that while we would share information to advance our respective investigations, we must also maintain some level of separation to ensure the integrity of each investigation. When examining issues regarding potential civil rights violations, we determined that any such violation are better addressed through a federal-led investigation, and issues involving potential criminal acts concerning the shooting are better addressed by a state-led investigation. With this in mind, our investigation focused on the events that took place in Ms. Taylor's apartment on March 13th. In the months since taking this case, our dedicated team of prosecutors and investigators with more than 200 years of combined career experience conducted a thorough investigation to better understand the events that led to Ms. Taylor's death. The team is here with me today. I want to personally and publicly thank them for their tireless work. These men and women are true public servants who for months have shown up every day with a desire for one thing, and that is to seek the truth. We decided while we would examine materials gathered by LMPD's Public Integrity Unit, we would need to conduct our own independent investigation and start from scratch in the interest of thoroughness, fairness, and finding the truth. There was no video or body camera footage of the officers' attempted execution of a search warrant at Ms. Taylor's residence. Video footage begins at the point that area patrol officers arrive at the location. Therefore, the sequence of events from March 13th had to be pieced together through ballistics evidence, 911 calls, police radio traffic, and interviews. We utilized information from the Kentucky State Police, local medical examiners, as well as working with the FBI Crime Lab in Quantico to secure a trajectory analysis and ballistics report. Our team conducted interviews in this case and spent thousands of hours examining all of the available evidence. We concluded our last interview in this case this past Friday and began our grand jury presentation on Monday. As long as the case is making its way through our legal system, I can only speak in general terms about our independent investigation and findings. As the prosecutor, I am prohibited by the Kentucky Rules of Professional Conduct from making public comments that could in any way prejudice this case as it moves forward. Each state has different rules about what prosecutors can and cannot say. The Kentucky rules are clear that I'm prohibited from making comments that could sway public opinion or heighten public condemnation of those involved in the case. These are crucial rules to ensure due process under the Constitution. When prosecutors prematurely release information about the case to the public, it can risk justice by poisoning the jury pool, violating the accused's rights to a fair trial, and even jeopardizing the final verdict. The success of our legal system is predicated on the principle that the accused is innocent until proven guilty. Despite passions, opinions, and desire for every detail to be known, the rule of law must apply. Justice must be done. In the early morning hours of March 13th, officers from LMPD executed a search warrant at 3003 Springfield Drive, Apartment 4. This was Miss Breonna Taylor's residence. The officers were advised by superiors to knock and announce their presence in serving this specific search warrant. The scope of our investigation did not include the obtainment of that warrant by LMPD's Criminal Interdiction Division. Federal law enforcement partners are conducting that investigation. Sergeant Mattingly and Detectives COSGROVE and HANKISON had no known involvement in the preceding investigation or obtainment of the search warrant. They were called into duty as extra personnel to effectuate the service of the search warrant. They only had information conveyed to them during their prior briefing. Evidence shows that officers both knocked and announced their presence at the apartment. The officers' statements about their announcement are corroborated by an independent witness who was near in a proximity to apartment 4. In other words, the warrant was not served as a no-knock warrant. When officers were unable to get anyone to answer or open the door to apartment 4, the decision was made to breach the door. After breaching the door, Sergeant Mattingly was the first and only officer to enter the residence. Sergeant Mattingly identified 2 individuals standing beside one another at the end of the hall, a male and a female. In his statement, he says that the male was holding a gun, arms extended, in a shooting stance. Sergeant Mattingly saw the man's gun fire, heard a boom, and immediately knew he was shot as a result of feeling heat in his upper thigh. Kenneth Walker fired the shot that hit Sergeant Mattingly, and there is no evidence to support that Sergeant Mattingly was hit by friendly fire from other officers. Mr. Walker admitted that he fired 1 shot and was the first to shoot. In addition to all the testimony, the ballistics report shows that the round that struck Sergeant Mattingly was fired from a 9mm handgun. The LMPD officers fired 40 caliber handguns. Sergeant Mattingly returned fire down the hallway. Mattingly fired 6 shots. Almost simultaneously, Detective COSGROVE, also in the doorway, shot 16 times. This all took place in a matter of seconds. In total, 6 bullets struck Ms. Taylor. Medical evidence obtained by our team indicates that only 1 shot was fatal. Further medical evidence shows that Ms. Taylor would have died from the fatal shot within a few seconds to 2 minutes after being struck. Detective Hankison fired his weapon 10 times, including from an outside sliding glass door and through a bedroom window. Some bullets traveled through apartment 4 and into apartment 3 before some exited that apartment. At the time, 3 residents of apartment 3 were at home, including a male, a pregnant female, and a child. There is no conclusive evidence that any bullets fired from Detective Hankison's weapon struck Ms. Taylor. The KSP ballistics analysis did not identify which of the 3 officers fired the fatal shot. After receiving that information, I asked the FBI crime lab to conduct its own analysis to see if they reached the same results. The FBI ballistics analysis concluded the fatal shot was fired by Detective COSGROVE. Our office looked at both reports to determine if there were major differences in the procedures used by each lab that would have led the FBI to identify who fired the fatal shot. Both law enforcement agencies use similar equipment and analysis, and each lab is highly respected for their work. There was nothing our investigators could point to, nor anything provided by the respective agencies that directly explains why one lab made the call while another did not. I think it is worth repeating again that our investigation found that Mattingly and COSGROVE were justified in their use of force after having been fired upon by Kenneth Walker. Secondary to this justification, The KSP and FBI ballistics analysis reached different conclusions, creating a reasonable doubt in the evidence about who fired the fatal shot. I certainly understand the public's desire for answers, and many have questioned the length of the investigation. Simply put, we had to try every means necessary to determine who fired the fatal shot before the investigation could be completed. With a thorough and complete knowledge of all evidence collected in this case, lawyers with our Office of Special Prosecutions presented the findings of our independent investigation before a grand jury comprised of Jefferson County residents beginning on Monday and concluding today. In Fletcher v. Graham, the Kentucky Supreme Court said that the grand jury has competing but balanced functions. On the one hand, its purpose is to investigate allegations of criminal conduct and determine if there is probable cause to believe that a crime has been committed. On the other, the grand jury serves to protect the public against unfounded criminal prosecutions where probable cause is lacking. The grand jury is unique in our criminal justice system because it operates independent of the court and the prosecutor. The hallmark of the grand jury is its independence from outside influence. This independence is necessary to ensure that justice is done both for the victims and for the accused. After hearing the evidence from our team of prosecutors, the grand jury voted to return an indictment against Detective Hankison for 3 counts of wanton endangerment for wantonly placing the 3 individuals in apartment 3 in danger of serious physical injury or death. The charge of wanton endangerment in the first degree is a Class D felony, and if found guilty, the accused can serve up to 5 years for each count. Kentucky law states that a person is guilty of wanton endangerment in the first degree when, under circumstances manifesting extreme indifference to the value of human life, he wantonly engages in conduct which creates a substantial danger of death or serious physical injury to another person. My office is prepared to prove these charges at trial. However, it's important to note that he is presumed innocent until proven guilty. During the last 6 months, we've all heard mention of possible charges that could be brought in this case. It's important to understand that all of the charges that have been mentioned have specific meanings and ramifications. Criminal homicide encompasses the taking of a life by another. While there are 6 possible homicide charges under Kentucky law, these charges are not applicable to the facts before us because our investigation showed, and the grand jury agreed, that Mattingly and COSGROVE were justified in the return of deadly fire after having been fired upon by Kenneth Walker. Let me state that again. According to Kentucky law, the use of force by Mattingly and COSGROVE was justified to protect themselves. This justification bars us from pursuing criminal charges in Miss Breonna Taylor's death. The truth is now before us. The facts have been examined, and a grand jury comprised of our peers and fellow citizens has made a decision. Justice is not often easy. It does not fit the mold of public opinion, and it does not conform to shifting standards. It answers only to the facts and to the law. With this in mind, we must now ask ourselves, where do we go from here? Will we continue to prosecute the charges brought in this case as it now proceeds through the justice system and moves to trial? That is our responsibility. And this will be done while the FBI continues its investigation into potential violations of federal law. I know that not everyone will be satisfied with the charges we've reported today. My team set out to investigate the circumstances surrounding Ms. Taylor's death. We did it with a singular goal in mind, pursuing the truth. Kentuckians deserve no less. The city of Louisville deserves no less. Every person has an idea of what they think justice is. My role as special prosecutor in this case is to set aside everything in pursuit of the truth. My job is to present the facts to the grand jury, and the grand jury then applies those facts to the law. If we simply act on emotion or outrage, there is no justice. Mob justice is not justice. Justice sought by violence is not justice. It just becomes revenge. And in our system, criminal justice isn't the quest for revenge. It's the quest for truth, evidence, and facts, and the use of that truth as we fairly apply our laws. Our reaction to the truth today says what kind of society we want to be. Do we really want the truth, or do we want a truth that fits our narrative? Do we want the facts, or are we content to blindly accept our own version of events? We as a community must make this decision. I understand that Ms. Breonna Taylor's death has become a part of a national story and conversation. But we must also remember the facts and the collection of evidence in this case are different than cases elsewhere in the country. Each is unique and cannot be compared. There will be celebrities, influencers, and activists who, having never lived in Kentucky, will try to tell us how to feel, suggesting they understand the facts of this case and that they know our community and the Commonwealth better than we do. But they don't. Let's not give in to their attempts to influence our thinking or capture our emotions. At the end of the day, it is up to us. We live here together. We work here and raise our families here together. I urge those protesting on the streets to remember this. Peaceful protests are your right as an American citizen. Instigating violence and destruction are not. I've spoken with both Mayor Fisher and Governor Beshears in the days leading up to this announcement, and I urge them to do what is necessary to maintain law and order and to protect our cities and our people. We have a long road ahead, both as we pursue this case through the criminal system and as we address the pain in the Louisville community. I'm committed to being part of the healing process. When tragedy occurs, we must mourn. We must also do everything we can to prevent it from happening again. Today, consistent with that view, I'm announcing that I will create a task force to review the process for securing, reviewing, and executing search warrants in Kentucky. The task force will consist of a variety of stakeholders, including citizens, members from the law enforcement community, representatives from the judiciary, defense attorneys, and elected leaders. I'll be issuing an executive order in the coming days to create this task force. I believe conducting a top-to-bottom review of the search warrant process is necessary to determine if changes are required and establish best practices. You have my word that I will also vigorously prosecute the criminal charges announced today. I can assure you that my team of prosecutors will continue to give this case their attention and time. We'll also continue to support the good men and women of our law enforcement community who put their lives on the line every day to protect and to serve. And I will fight for those across our state who feel like their voice isn't heard, who feel marginalized, judged, and powerless to bring about change. In a world that is forcing many of us to pick a side, I choose the side of justice. I choose the side of truth. I choose a path that moves the Commonwealth forward and toward healing. You have that choice as well. Let's make it together. Thank you, and God bless. I'll now take some questions. I won't get into the specifics of the makeup of the grand jury.
Yeah, you mentioned that Breonna Taylor was hit by 6 bullets. You identified the one that killed her. Who shot the other 5 bullets, and did any of Hankinson's bullets hit Ms. Taylor?
Based on the evidence, there's nothing conclusive to say that Detective Hankison's, any of his bullets hit Ms. Taylor.
I'm just curious
Yes,
what
sir.
your message would be to the family and those who support her in the community, because based on what you're saying today, the grand jury basically found that none of the officers involved are directly responsible for Breonna Taylor's death.
Well, as I said from the beginning, and I appreciate that question, this is a tragedy. And sometimes the law, the criminal law, is not adequate to respond to a tragedy. And I fully acknowledge that, and I know many that are watching today and those that are listening recognize that as well. But the response is that the grand jury was given all of the evidence, presented all of the information, and ultimately made the determination that Detective Hankison was the one to be indicted.
To be clear, did your special prosecutors make a recommendation to the grand jury?
Grand jury proceedings are secret, and so I'm not going to get into the specifics of details about that proceeding. What I will say is that we presented all of the information, and they ultimately made a determination about whether to charge. In this instance, they decided to indict Detective Hankison.
One question. Self-defense, do you think state law needs to be changed?
I'm sorry, say that again?
When it comes to officers firing back in self-defense, do you think the current state law needs to be changed with cases like this?
Well, what my role as the special prosecutor in this case was to provide the information and facts to the grand jury. Detective COSGROVE and Sergeant Mattingly were justified in returning fire because they were fired upon. I'll leave it to others to make determinations. We have vigorous self-defense laws in this state, and that is something that existed prior to this case. I'll let others make judgments about that. Yes, sir.
One big question surrounding this case is whether or not the officers knocked and announced their presence. Talk about the evidence that you came to that they did announce their presence.
Yes, the statements that were made by officers there the night or the morning of March 13th show that they did knock and announce. The important point here is that information was corroborated by another witness who was in close proximity to apartment 4, who corroborated that information and said that there was a knocking and announcing by the officers.
Was the witness a civilian or a law enforcement?
The witness was a civilian.
If a wanted endangerment takes place while there is a death involved, would that not be a manslaughter charge? If there was a death that occurred during a wanted endangerment?
Well, Chris, to your question, I think it, again, is important to step back and recognize that what we did was uncover all the information and facts related to the morning of March 13th, and then provided that information to the grand jury. The grand jury had every piece of detail needed to make their assessment and their judgments. And ultimately, their conclusion was that the decision needed to be made to indict Mr. Hankison.
Mr. Cameron, Rukmini Kalimaki with the New York Times. Right here,
I'm
sir.
sorry, yes,
Hi,
ma'am.
2 questions for you. Number 1, you said that she was shot 6 times, yet her death certificate says 5. Can you please explain the discrepancy? And the second thing is journalists in this room, myself included, have taken apart that apartment complex looking for witnesses to the point that you made about the knocking and announcing. Of a dozen witnesses that I spoke to, only one, a man who was directly upstairs, heard them announce. Do you think that's enough in the middle of the night when somebody is asleep for just one person in a tight-knit apartment block to have heard that? Is that a sufficient way of announcing?
Well, let me try to answer your second question first. Your question was, is it enough for me? I think the more pertinent question is, what was the evidence provided to the grand jury? What was sufficient for their purposes? They got to hear and listen to all the testimony and made the determination that Detective Hankison was the one that needed to be indicted knowing all of the relative points that you made. As to your first question, can you repeat it one more time?
Her death certificate says 5, and yet you are saying 6. Today's the first time I'm hearing 6.
Yes, sir. So there is a bullet that was lodged, and bullet might be too generous a term. There was an object that was lodged into one of her feet, and so that is what is being referred to as the 6th, I guess, projectile.
Are you going to release the full?
Joe?
Are you going to release the full grand jury report?
Can you say that one more time?
Are you going to release the full grand jury report?
Well, I am right now, because there is a pending indictment. I think it is our practice, and because there is an ongoing FBI investigation, to revisit that question. But at this point, I don't think it's appropriate for us to release any information.
And just for clarification, you said that Hankinson fired 10 times from the outside into apartment 4 and into apartment 3, with no conclusive evidence any of those shots hit Taylor. Can you expand on that just a little bit more?
Well, that is what the evidence shows, is that there was nothing conclusive to demonstrate that any of his bullets hit.
Does that leave the door open for the fact that maybe one of his shots did hit her? Or?
Well, again, all the evidence was given to the grand jury, and they made the decision that wanton endangerment was the charge to file or to indict against Mr. Hankinson.
Okay, and thank you.
Yes, Wendy. Well, your last question about providing information, in any investigation, criminal investigation, the best practice, and this is whether on the state or federal level, is to not make too many specific comments about the investigation because you do not want to compromise that investigation. There are also ethical considerations as investigators and prosecutors that we're responsible to abide by as well. Some of those obligations continue now because we have a responsibility to pursue the prosecution against Detective Hankinson. It's my judgment very early on that we needed to take this case in the Attorney General's office. As you know, the Commonwealth's attorney was conflicted out of this case because of another matter that he was pursuing. I could have farmed the case out to another Commonwealth's attorney in one of our 120 counties. Instead, I did not do that because the resources that we have to bring to bear and the relationships that we have with our federal partners, in my judgment, were needed to uncover the truth in this case. And part of the reason the investigation took so long is because we needed to make sure that we were doing a thorough job of looking at all the facts and gathering all the materials, interviewing witnesses, making sure that all of our people felt confident in their presentation to the grand jury. I will remind you, as late as Friday, we were still interviewing people in this case. And so the length of it is because this case deserved thorough and fair analysis. That was needed and deserved by Breonna and by her family, for the officers involved, for the community of Louisville, and for the Commonwealth. We needed to have a thorough investigation. We also got the FBI involved in terms of the ballistics report. We needed additional, their ability to scrutinize and make an independent assessment as well. And so the length of the investigation was a reflection, I hope people understand, of how important it was that we got this right. We didn't want to rush it, and we did not. And I'm grateful to the team that is behind me for the work that they did. Look, over 200 years of combined experience. These are prosecutors and investigators who don't care about political distinctions, don't care about influence in any particular regard. What they care about is the truth, and we presented that to the grand jury.
Sir, sorry.
I'm sorry. I won't get into what our private conversation was. Yes, ma'am.
Yes. What do you say to people who say this is just another example of the Black community not getting full justice? And what specifically do you plan to do to calm a community that's long been hurting? And do you understand that anger that people might feel?
I certainly understand the pain that has been brought about by the tragic loss of Ms. Taylor. I understand that. As a Attorney General who is responsible for all 120 counties in terms of being the chief legal officer, the chief law enforcement officer, I understand that. I understand that as a Black man, how painful this is. And which is why it was so incredibly important for make sure that we did everything we possibly could to uncover every fact. And I know, look, this team, myself, the members of the representatives of the Attorney General's office have taken a lot of criticism and scrutiny. But that scrutiny in many ways was misplaced because there was not a day that people in this office didn't go to sleep thinking about this case, and it wasn't a day where the first thing on our minds is getting to the truth in this case. And obviously, again, the criminal law is not meant to respond to every sorrow and grief, and that is true here. But my heart breaks for the loss of Ms. Taylor, and I've said that repeatedly. My mother, if something was to happen to me, would find it very hard. And I've seen that pain on Ms. Palmer's face. I've seen that pain in the community. And what our responsibility in the AG's office was to make sure that we uncovered every fact, that we utilized every resource that we could bring to bear to uncover the facts and the truth, and that's ultimately what we presented to the grand jury. On the question of what I'm going to do, I've talked to partners in the community about helping to be a constructive member of any conversations moving forward. I recognize in my remarks, I mentioned the fact that we'll be establishing a task force in the coming days ahead to look at best practices for warrants. So there is a lot that I can do in this platform to help.
Okay, sir, this is Maria Sacchetti with the Washington Post. Just had a couple of quick questions,
I
please.
hear your voice. Okay.
Hi,
yes,
sorry, over here in the back. Just wanted to double check. Did the grand jury ever consider the charges of manslaughter, reckless homicide? And if not, could you please explain why? And do you anticipate any other charges in this case?
I apologize. Could you say that a little louder?
Sure.
I think I got...
Sure. Did the grand jury ever consider manslaughter or reckless homicide or those kinds of charges? And if not, please explain why. And do you anticipate any other charges, or is this it?
I won't get into the specifics again of the proceedings themselves are secret, but what I will say is that our team walked them through every homicide offense and also presented all of the information that was available to the grand jury, and then the grand jury was ultimately the one that made the decision about indicting Detective Hankinson for wanton endangerment. I think that in terms of what happened the wee hours of March 13th, in terms of that particular or specific date and what happened that night in the apartment, I think it is unlikely that there will be any additional prosecutions that come from that event itself.
Attorney General, so can you go into the confusion over the fatal shot that was fired and kind of what the issue was there in terms of determining that? And then also, did you present to the grand jury with any charges against Mattingly and COSGROVE?
Well, so as to your first question, what I think you asked about was
confusion over the fatal shot.
Yes, the reports that were provided to us by the Kentucky State Police and then the FBI as it relates to ballistics. So initially we got the report from Kentucky State Police and it was inconclusive about making a determination into that fatal shot. And so again, with the relationships that we have with our federal law enforcement community, and namely the FBI, I thought it imperative that we utilize that resource. And so they undertook an independent analysis and review of and conducted or provided a ballistics report. There is nothing that this team was able to glean suggesting that there was an objective reason for why FBI was able to conclusively or definitively state that Mr. COSGROVE fired the fatal shot. Both, again, KSP, their lab, well-regarded, well-respected, FBI, equally regarded and respected. That said, it certainly creates some issue in terms of providing that information to the grand jury and providing that at any subsequent prosecution. And so it was, from our judgment, important to provide both of those to the grand jury and then ultimately let them make a determination about what to do with that information.
And were they presented with charges for Mattingly or COSGROVE?
I'm sorry?
Mattingly and COSGROVE. Were they presented with any charges for Mattingly or COSGROVE?
Well, what I will say is that they were walked through all the homicide offenses, and with that information and the information and facts that were provided to them that we uncovered in our investigation, they made the determination that Detective Hankinson was the one that needed to be indicted here. Yes, ma'am.
General Cameron, just a couple questions. First of all, does Catholic doctrine apply at all in Kenneth Walker's defense of his home? The second question is, could you give me an idea of the percentage of people of color on the team of investigators presented to the grand jury?
So what I will say is there's obviously I don't want to get into the proceedings related to Mr. Walker. That's a separate, so I'm not going to have any comment on that. This team behind me presented to the grand jury. And your other question was about the racial makeup of? Well, I'm black, and I speak for the entire department. And I hope that will satisfy that question. Yes, ma'am. Yes, ma'am, I'm sorry.
I know that you said the investigation has obviously taken months and it was presented to the grand jury Monday. Can you tell us, when did the grand jury actually, how long did they deliberate? Did they begin on Monday or did they begin Tuesday? And that was of this week, correct?
The grand jury was presented with the information today. I won't get into the specifics of when they began their deliberations, but I will say that they started early Monday and concluded sometime before noon. And so they heard everything they needed to hear. We didn't withhold anything from them, and I hope that satisfies your question.
Okay. General, can you tell me a little bit more about this task force? You know, Senate President Stivers and Representative Scott are introducing warrant bills for the next legislative session. Are they going to be on this task force perchance? And will you be taking some of the information from the bills they pre-file to work with on this?
Well, I don't want to put, obviously, the cart before the horse, but I did mention in the remarks that we are certainly going to have elected leaders on this task force, and I imagine that some of the policy questions and some of the policy proposals that have already been put forward and have entered into the public conversation will be a part of this task force. But I want to make sure that people recognize that this task force is being established not to demonize any one side or any one department or agency. I think it's a healthy thing for the Attorney General from time to time to be a part of a conversation with all 120 counties. I'm not talking or singling out any county specifically, but with all 120 counties about best practices that can be utilized. I had a recent conversation with somebody that said there is always room for improvement. I think that's important in any industry, important in any job. And so as part of my role as the Attorney General, I certainly recognize the part I have to play in making sure that all of our systems in government are improved upon, whether it be because of a particular matter that occurred or because from time to time it's just the responsible thing to do.
Did
Yes, sir.
any of the officers
I'm
ask?
sorry, Joe?
Yeah. Did any of the officers ask to testify or present evidence to the grand jury, and were any allowed to?
Well, what I'll say on that is, again, I don't want to get into the specifics, but testimony was heard by the grand jury of all sorts of witnesses and folks. And so, again, all relevant information was provided to the grand jury for them to make their assessment. Yes, sir.
When you look at the analysis of the path of the bullets, how was it that Kenneth Walker, who fired the shot at the officers, was not hit, and Breonna Taylor was hit so many times?
Well, that's part of the tragedy here. And again, I don't want to get into the specifics, but the fact that she was hit breaks my heart, and it breaks the collective heart of all the country. But I don't want to get, because we have now a open prosecution, I don't want to get too into the details of the trajectories themselves.
Two follow-up questions. One, I understand that the names of grand jurors aren't released, but what rule or standard prevents you from releasing the racial and gender makeup of the grand jury? And number two, you've mentioned that COSGROVE fired the fatal shot, but could you clarify how many shots in all that hit Ms. Taylor were fired by Mattingly, and how many shots that hit Ms. Taylor were fired by COSGROVE?
Well, as to the last question, inconclusive in terms of how many shots from each officer. We weren't able to identify with that level of specificity. As to the question about the makeup of the grand jury, we might be able to, I need to confirm on that front about. Yeah, you know, the fact that this has received so much scrutiny, I think it'd be inappropriate for me to share the information about the makeup of the grand jury, just to the extent I can protect them.
Will you release the investigative file or recommend that LMPD release it?
Well, look, the role that we now have is to pursue the ongoing prosecution against Detective Hankinson. And so I think it'd be irresponsible at this juncture for this office to release any sort of file, again, because we have this ongoing prosecution. And I'm not going to comment on, and I think I certainly shouldn't be recommending, again, because of the ongoing prosecution, any sort of recommendation as to relates to a release of a file.
We're going to have time for 2 more questions.
Oh, Daniel, okay. Well, I certainly don't think that whether it's the grand jury or our responsibility as the investigators or prosecutors, it's to find the truth. And so when folks from outside of the Commonwealth suggest or make their preferences or their opinions known, it should have no bearing on our role as prosecutor and as investigator and fact finder. Even with folks within the Commonwealth, again, this is a tragedy. I don't want to lose sight of that, but we do have a responsibility to look at the facts as they are, and we can't be in the business. I don't think we want a justice system that is in the business of fashioning facts or laws to a particular narrative. We have to be in the business of presenting the information to the grand jury and ultimately allowing them to make a decision about what to do subsequently.
Last question.
Yes, ma'am. Far in the back. I apologize. Actually, we'll take these last two here. Okay. So either one can start. Sorry.
I apologize. Thank you very much, sir. I wanted to ask if you, if you believe personally that someone should have been charged with homicide or one of the similar charges in this case, and if you could please walk us through what happened after the officers knocked on the door. Did they hear an answer? How long did they wait before everything erupted? But both of those questions, please, and thank you very much.
As to your first question, again, this is about what the grand jury decided. One of the misconceptions out there is that the Attorney General's office was in the business of making charges, and that's just simply not the case under Kentucky law. Our role is to present the information to the grand jury. We dispense with that responsibility. We did it after a protracted investigation that uncovered all of the facts. That was our role. That was our responsibility. And we presented everything to the grand jury for them to ultimately make a judgment about what to do next. And in this case, in this instant, they decided to indict Detective Hankinson. As to your other question about what was provided to the grand jury, I can't get into the details of the specifics on that particular issue. Yes, ma'am.
Yes, sir. In the beginning, you said that you spoke with Breonna Taylor's family today. I know you can't tell us word for word what they said to you, but how was the news received?
Well, it was a hard meeting, and I won't go any further. I won't elaborate. But it was a difficult meeting, and look, when I ran for this office, I ran because I had some singular ideas in mind, and you never know exactly what issues you'll be presented with and what challenges you'll be presented with. And today was one of those challenges, to have to sit in that room and provide the information to Ms. Palmer and to other members of the Taylor family. It's been a difficult day. This is a difficult day for everyone standing up here. This is a difficult day for those here that have to report this. And it's a very difficult day for Louisville, all of the Commonwealth, all of the country. I recognize that. And I certainly recognize the responsibility that I have to help in the healing process. And as I noted in my remarks, I hope that those that are home watching, those that perhaps have ideas about being angry or pained by this decision, I hope we will respond in a manner that respects our First Amendment rights, but also respects our responsibility as the Bible talks about loving our neighbors, and that we can do so keeping Breonna Taylor's legacy in mind, but also in a way that respects our Louisville, our city, the city I live in, that respects all of our communities. So again, this is a hard day. I am under no illusion that it is not. And all I can offer is that our office uncovered every fact that was relevant to the wee hours, the morning hours of March 13th. We provided that information to the grand jury, and you all now, whether you're sitting here or whether you're at home, know the results of that process. And now we have the responsibility to prosecute that indictment, move forward in that matter. But all of us have a responsibility to work together, to find common ground, to find ways to love one another, and just be good neighbors. And so that's what I implore as you all report on this in a responsible manner. That's what I implore those that are watching on television, is that we all have the responsibility of coming together now. I hope that you will take that charge seriously. Our governor likes to talk about Team Kentucky, and I believe him earnestly. in that charge. And I hope that that extends to the results that were issued here today, and I hope that extends to all of our neighbors and all of our communities. Thank you, and God bless.
The Kentucky Attorney General wrapping up his news conference there live in Frankfort. Mattingly and COSGROVE justified with their use of force, according to Kentucky Attorney General Daniel Cameron. 6 bullets hit Breonna Taylor. 1 shot was fatal, that coming from Officer Miles COSGROVE, a name that we had not talked about a lot, but was one of the initial 3 on that March 13th night. We want to bring you some reaction that's coming in as we continue our coverage here live on WHAS 11 News. We expect Louisville Mayor Greg Fisher to be briefing the city here in just a little bit. As we wait for that, we've also been seeing some activity on Twitter and some statements being made. The attorney Ben Crump coming out just a little while ago, as you can see his statement there on the screen. His reaction there coming right after the grand jury came out with its decision, and it reads, the Jefferson County grand jury indicts former officer Brett Hankison with 3 counts of wanton endangerment in first degree for bullets that went into other apartments, but nothing for the murder of Breonna Taylor. Ben Crump saying this is outrageous and offensive. Now, just a few moments ago, sent to the WHAS 11 newsroom, an email from Attorney Kent Wicker, former prosecutor with the U.S. Attorney's Office, representing John Mattingly. The grand jury's decision to not indict John Mattingly or Detective COSGROVE shows that the system worked and that grand jurors recognized and respected the facts of the case. The death of Breonna Taylor is a tragedy, but these officers did not act in a reckless or unprofessional manner. They did their duty, performed the roles as law enforcement officers, and above all, did not break the law, from Attorney Kent Wicker. Now let's go to Shay McAllister. She is live. She's been following the protest groups ever since we learned the decision from the Jefferson County grand jury. Shay, how are things going so far within the last hour?
Hey, Doug, so we're about just over 2 miles from Jefferson Square Park, where this group started marching right around 1:30, right after the grand jury's announcement. The group has grown considerably. Many people joining in along the way. We're on East Kentucky, so how this went, we headed down 6th Street, down Broadway, got onto Kentucky, and they've moved down further and further. And if you can look, several dozen, and it takes up several blocks. Early on in the march, there was a U-Haul truck parked right off of Broadway where they had what they called shields in that back of that U-Haul, and that's what you can see back there. They handed them out to create this line. They've encouraged people to stay behind those shields, but many are joining in front of them, and at every intersection they regroup. Doug?
So Shay, you have left the downtown security zone, and right now are you, do you have any direction on where exactly you're heading next?
Doug, all signs show us that they are just making this up as they go. At every single intersection, they regroup and discuss where to go next, which direction that they want to go in next. Right now, we've just stayed on Kentucky, like I said, about 2 miles from Jefferson Square Park. No one seems like there's any stopping anytime soon.
Okay, Shay, thank you very much. And let's go to Chris Williams. He is live. He covered the Attorney General's news conference in Frankfort. Chris, I know you were able to ask a question there about some of the charges there. Also, the Attorney General saying unlikely any other charges will be coming from the night of March 13th.
And that was something that we were waiting to hear, of whether we thought anything else with the state charges. He did leave the door open for what the feds are doing, saying that the feds are investigating that search warrant, investigating any civil possibilities of civil charges, that the charges that were being investigated by him and his team as special prosecutors and special investigators was to look into any state criminal charges against the 3 officers who were involved. We learned that Officer Detective Hankison is facing 3 charges of wanton endangerment, and the wanton endangerment charges came because the bullets, the ballistic report showed that Hankison's bullets went into a neighboring apartment, and there were the 3 people living in that apartment at the time. But they also said, the Attorney General also said that the 2 other officers, Mattingly and COSGROVE, would not be charged because they were justified to protect themselves when Walker fired upon them. He also said that the investigation found that Walker fired 1 bullet and that Breonna Taylor was hit by 6 bullets. The bullet that killed Breonna Taylor, interesting enough, the state crime lab could not determine what gun fired that bullet, but when they sent it off to the FBI, the Attorney General said that they were able to determine through the FBI crime lab at Quantico that that bullet came from COSGROVE. COSGROVE, again, not facing any charges, but the Attorney General spoke for about 50 minutes, 52 minutes, according to my watch, about this day, calling it a difficult day, and here's how he described the grand jury coming back.
The use of force by Mattingly and Cosgrove was justified to protect themselves. This justification bars us from pursuing criminal charges in Miss Breonna Taylor's death. The truth is now before us. The facts have been examined, and a grand jury comprised of our peers and fellow citizens has made a decision.
I asked the Attorney General, other reporters also asked the Attorney General about those charges, trying to figure out whether they suggested charges. I asked whether the wanton endangerment could have been a manslaughter charge because there was a death at the scene of that wanton endangerment. But every time he was asked, the Attorney General kind of punted on that, saying that it was the grand jury's decision on what charges to come up with, saying that the Attorney General's office was not in the business of trying to ask for a charge, that they were waiting to see what the grand jury decided. Also going through my notes here, Doug, the Attorney General paused for a moment, almost appearing to become a little bit emotional when he was asked about the conversation with Breonna Taylor's family. And he talked about the difficulty of trying to have to explain to Breonna Taylor's mother the charges that were going to be brought, knowing that so many close to the family wanted more strict charges. And he talked about his own mother, saying that he could envision what it would be like if something had happened to him, and seeing the look of pain or hearing the pain from Breonna Taylor's mother. He could imagine what it would be like for his mother and the pain that she would endure if that were the case. But again, Doug, the Attorney General spent 52 minutes by my watch laying out the case here, talking about the investigation, saying that they started with what the LMPD had looked at, but that they went ahead and started their own investigation. He also pointed out that they kept their investigation separate from the feds because they did not want the FBI investigation or their investigation to muddy the waters for the other. He also promised that it's now time to prosecute this case and that he will do it vigorously. He talked about the community across Kentucky needing to come together and announcing that he will soon call for a special task force to look into search warrants and the way search warrants are gotten or received here in the Commonwealth of Kentucky. Doug?
Chris, I thought a really interesting question was about the other bullets that hit Breonna Taylor. The Attorney General saying we weren't even able to identify with specificity if the other officers also shot her, but they are able to identify that Miles Cosgrove fired the fatal shot.
Yeah, and I asked a question, where were the other 5 bullets? And another reporter asked about, well, the death certificate says that she was shot 5 times. You're talking about 6 times. The Attorney General first said that that 6th bullet was a bullet or a bullet fragment that was later found in Breonna Taylor's foot, and that's why that information was different. But it was interesting that he could say that Cosgrove's bullet, after consulting with the FBI and Quantico, that it was Cosgrove's bullet that killed Breonna Taylor, and he could say that it was not likely Hankison's bullets that hit Breonna Taylor the other times, but that it was, they couldn't determine who those other bullets belonged to, the other 5 bullets that hit Breonna Taylor that night.
He was really pressed with some personal questions. Is this another example of the black community not getting justice?
Well, you'll have to ask them and those who are watching it. The Attorney General tried to explain when one of the reporters asked, well, what was the racial makeup of your special prosecution team? And he says, well, I'm black and I speak for my department. He didn't go into that. He was also asked several questions about race of the jury, the grand jury, and he said that he would not get into specifics about that. He cited the heightened awareness of what was going on with this case, saying that he did not believe that giving that data out was good for this case.
Okay, Chris Williams live in Frankfurt covering the news conference. Thank you very much, Chris, for your insight into some of the finer details of the news conference. The Attorney General saying John Mattingly was the first and only officer to enter the apartment. Miles Cosgrove, as Mattingly identified in a recorded interview, was behind him in the doorway. And again, as we are learning this afternoon from the Attorney General, fired the fatal shot. Here's what we know about Detective Miles Cosgrove. He's been with LMPD since 2005. His personnel file includes commendations for handling a dangerous situation and training graduation ceremonies, but it also includes reprimands for not appearing in court and violating courtesy policies. Cosgrove was sued for excessive force stemming from an officer-involved shooting in 2006. But court records show a judge ruled he didn't break any laws. So what happens next with the officers involved? We know that Brett Hankison has been fired. That happened back on June 23rd. The Louisville mayor expected to brief the city here in just a little bit. But right now I'd like to bring along one of our legal experts we've been talking to for months, the retired justice here in Jefferson County, Judge Janice Martin. She was also the first African-American woman elected in the state of Kentucky. Judge Martin, thank you for joining me. You and I have been following the evidence together over the last several weeks. Give me your initial opinion on what you saw today, both from the grand jury and the Attorney General.
Thank you, Doug. It was interesting. What I picked up on initially was the Attorney General's comment that it was his job to investigate the events that led to Breonna Taylor's death, that he was going to start from scratch in finding the truth and gathering all the facts and the materials. Well, when you consider that they did not even investigate the validity of the search warrant, I don't know how you get all of the information in finding the truth. Professor Markison talked about that initially, but I think it's key. I mean, how do you examine or investigate her death without looking at that search warrant? But for that search warrant, she would be alive.
And again, he's saying that the search warrant is going to be taken up by the FBI as part of the civil case. Do you agree with the Attorney General's decision in this, justified use of force based on Kentucky law?
Well, that's interesting that we talk about that. He made a point of saying that only Detective Mattingly entered the home. Only Detective Mattingly was fired upon. And so I was wondering, because Professor Markison pointed out, look, if you make a finding that there's wanton conduct, how do you explain 16 shots fired by Cosgrove, who was not fired upon? So I'm not going to, give a legal opinion as to whether or not that was correct. I'm just throwing that out.
The grand jury earlier today, I'm interested in your opinions on the grand jury. You saw that play out here. The wanton endangerment charges against Brett Hankison.
I think that that's appropriate. The wanton endangerment charges are clearly appropriate as it relates to that officer. My question, though, is should there not have been wanton endangerment charges considered perhaps for the other officer who fired 16 times and he was not fired upon? I am also having trouble with, if you're making a determination that there's wanton conduct, we really don't have conclusive proof as to how many of those shots actually hit Breonna Taylor, where those shots came from. They're saying that one shot from Cosgrove hit her, and that's the fatal shot. But I find it interesting that we have two inconclusive reports.
I was honored to be able to cover your election. You won by a huge margin here in Jefferson County in the early 1990s. And I'm interested in your personal opinions as well. As an African-American woman, an historic figure in our state, the question was asked to Daniel Cameron, is this another example of the black community not getting justice? Give me your thoughts on that.
Well, I think it's a more important issue as to whether or not justice was received for this community in general. and not looking at that search warrant initially. This is very disturbing that someone is sleeping in their home and they are killed based upon a search warrant that probably never should have even been executed.
Well, we can talk about the search warrant. We've sent you the search warrants. You've been reviewing them as well. The search warrant in question, that what people, we should brief folks on, the information was taken in January by surveillance by Joshua Janes, a figure that hasn't been talked about a lot in this case, but has since come to prominence lately. That information from January was then put on the March search warrant put in front of Judge Mary Shaw. Now, you've told me early on you found that problematic.
Well, I think the information was stale, clearly. And certainly I'm not criticizing Judge Shaw. She's a great judge. She does a good job. But she was misled. She was led to believe, obviously, that this required a no-knock search warrant when it did not. There was boilerplate language that was used at the top of that warrant that indicated Affian is requesting a no-knock entry due to the nature of how drug traffickers operate. These drug traffickers have a history of attempting to destroy evidence, have cameras, are likely to dispose of evidence if the officer's approach is compromised. Now, that same language was used on all of the warrants. Clearly, that was appropriate as it related to the other 4 search warrants because we had a history of drug trafficking behavior. We had criminal history regarding those defendants. There was a confidential informant purchase of drugs from those homes. They had pending drug charges. They were observed, engaged in conduct consistent with drug trafficking. But none of these factors were present as it related to Breonna Taylor. So Judge Shaw was led to believe, by including that information on that warrant, that there was more there than met the eye. Clearly, the evidence was stale because the only thing that tied a warrant to Breonna Taylor was the alleged pickup of a package from her home. We don't know what that package was. It's just as, it could just as easily be considered that there was nothing suspicious about that package. It could have been clothing. It could have been merchandise. We don't know what that was. That package was never intercepted. So,
now we wait for the FBI on the civil rights investigation there. Judge Janice Martin, I thank you so much for your opinion, of course, your service to our community. Retired Justice Janice Martin of Louisville giving us her reaction. Let's talk to Sanait Gabregegadis now. She has been following the case from the very beginning, and she's also joining us live from the downtown area. How are things around you, Sanait? Things still relatively peaceful around you, it seems.